It's time for another installment of Martial Law, and this radio program is intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. One of those would be Mr. Marshall Chriswell, who's on the line with us this morning. Good morning.
Hey, good morning, Todd.
It's good to have you with us here today as we talk real estate again. Let's talk about that a little bit. When you have a property and you're trying to sell it, and I'm thinking of a home here, and you might know something about that property that you think you don't have to disclose, some sort of defect, some sort of thing that would affect the value of the property. Just let's talk about that here this morning. What do you have to disclose when you are selling a home?
Sure. When you are selling residential real estate, under Pennsylvania law, the seller is required to disclose all known material defects to any potential buyer. And so when we talk about obviously a known material defect, you've got it's something that that is within the seller's reasonable knowledge that there is this problem. And when you say material defect, you're talking about something that substantially affects the home's value or the safety of the residents. Mm-hmm. So there are small things. Maybe there's a leaky faucet that just needs a new seal or something tightened. There's nail holes in the wall and things like that wouldn't be material defects. But many of the things that can be wrong with a home, obviously, and its structure and the systems in the home would certainly be material and would have a substantial effect on the home's value.
Some things might be pretty obvious to the naked eye. I look up, I see that the roof needs replacing. Is that something I have to disclose, or do I think the buyer can see that those shingles are bad and they need replaced? Do I really need to tell them?
So if it is readily observable by a potential buyer, then the seller generally does not have a duty to disclose. If it is so obvious that anybody walking into that room or looking at the house would see it, then you don't necessarily have a duty to disclose it. Now, shingles on the roof. I'd certainly be disclosing that. Not for better or worse. Not every home buyer climbs up to the roof before they buy it, and not everybody has a home inspection done. So whenever you're disclosing things, and before every sale or whenever you put a house on the market, there have been forms that have been generated to comply with this law. If you use a realtor, they have a standard form. I know I have one. And you're going to be completing this form where you are disclosing everything that you're aware of, and if the house has been remodeled, if you've done structural changes, any title issues, all kinds of things. You want to I always encourage people to over-disclose, right? You want to report everything that you know, because if that becomes a problem in the future, you're in a much better legal position. If someone tries to sue you because their basement's flooding or their roof's leaking, that if you're in a much better position if you have disclosed those things.
All right, so some of those less obvious things, something a little bit more subtle, problem with the water well, for instance, that
Certainly.
Would be something. I would assume drainage problems off of a neighboring property even?
Yes, if you have had any drainage issues, erosion, any of those types of things are certainly material defects that are to be disclosed. Even things like if you had a boundary dispute with a neighbor, if you're aware of any, like I said, title issues, all kinds of things. Anything that you're aware of that's going to affect the value that the buyer is getting in the purchase.
Now, okay, so one of the things that we might want to drill down here a little bit on is the fact that you said a known problem, something that you know is wrong with that property, and there could be things wrong with that property that you don't know. Right.
So and this comes up a lot in the context of someone selling the property as if you're the executor or administrator of an estate and you didn't necessarily live there. Mm-hmm. You're selling under a power of attorney for someone and you didn't live on the property. You're a landlord and you didn't reside there. Obviously, you're responsible for the property, but you haven't been residing there. So in those instances, and the law does contain some exceptions for situations like estates and trusts and things like that. But even if you're exempt from disclosure, you still need, if you're exempt from completing the form, you still need to disclose things that you know about. So it is only things that are within your reasonable knowledge, and you can't bury your head in the sand either, right? If you there's a big crack in the basement, and you look at that and you think, oh, wonder if that's structural. Well, I'm not going to get anybody to check it out, and I'm going to totally ignore it. And then you sell the property, and So if there are things that are within your reasonable knowledge that this is a problem, could reasonably be a problem, then you need to be disclosing those things. It is required by law, and it's for your protection.
There are three things I absolutely can't stand: rats, cats, and bats. If there are bats in the belfry, if there are rats in the basement, would those qualify as things that we need to report?
Yes, if you have an infestation, whether it's termites, or as you said, rodents or any other pests, you're going to want to disclose that. Getting rid of these things can be an arduous and expensive process, for a potential buyer. So you certainly want to disclose it, and I would encourage a seller to, like with a lot of these things, take care of it before you put the place on the market.
Mm-hmm. Okay, let's talk about ramifications. What is the end result if I do knowingly sell a property, and I know that there's something wrong with it, I do not disclose it? What can happen?
So if you don't tell a buyer about a known defect, you can be found legally responsible for the costs of that repair, as well as other damages that is suffered by the buyer. So if it's a problem where they actually have to vacate the home while this is being fixed, then you can be responsible for their costs of relocation, staying in a hotel, renting a home, as in addition to the costs of repair. So if it's something that causes someone certainly physical harm, if someone sustains an injury because that porch step was is faulty and you didn't tell them about it, you're going to be liable in a personal injury case. You can be sued for negligent misrepresentation, fraudulent misrepresentation. You can be sued for violation of the Pennsylvania seller's disclosure law, which generally applies to residential real estate where you have anywhere up to 4 living units. So landlords with duplexes or triplexes or quadplexes, those are all on the table there. So you are legally responsible for material defects that you do not disclose.
All right. So you mentioned a couple of moments ago that you have a form that you use when someone is at the beginning of this process. Obviously, as you said, you want to do this at the beginning and maybe even before you put it on the market. You want to get this taken care of. That's when you would, I assume, recommend that they visit the attorney so that you can help them through this process?
That's right. Like I said, if you're using a realtor to sell your home, they're going to be aware, and they have forms that are generated by the Pennsylvania Association of Realtors, and they're going to provide that to you and make sure that you disclose it. Now, I get a lot of calls from people that have realtors about how to complete the form, right? Because the realtor can't give you legal advice. If you have any questions about how to complete that, you call an attorney. But more and more often, we're seeing people that are selling their home without professional help. As far as getting a realtor to list the property, people are using social media and other advertising methods and trying to sell the home themselves before they commit to a listing agreement with a realtor. And in the vast majority of for sale by owner situations, the seller does not know about the seller disclosure law, does not know that they need to complete this form or provide written disclosure to all potential buyers of any known material defect. And so, yes, particularly if you are selling your home without the assistance of a realtor, you want to get an attorney on board early so that you comply with the law and you don't run into a problem down the road.
Save yourself a headache or two, wouldn't you?
Absolutely.
Yeah. All right, so if somebody wants you to be that attorney, what should they do?
You can call me at 724-465-5826. Stop in and see me in the old RMP Cole headquarters, which is at 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Very good, Marshall. Thanks for joining us this morning.
Thanks, Todd. Have a good week.
You too. We'll see you. It is the voice of Indiana County. It's WCCS 101.1 FM and AM 1160. AM 1160.